Hello again, everybody. I'm Michael Redden, and today we're going to talk about how you should leave things to your heirs. We're not talking about the trust or things like that. We're talking about, should you give them some money at 21, at 35? Should you just give it all outright? Should you lock it up and with strings attached forever, or what? Well, I would tell you that for most people now, the biggest way we avoid that, problem of money where you may have made a fortune in your lifetime or made a very respectable nest egg, and if you pass that to the next generation, usually by that third generation someone's broke again. And that's really because we don't do a good job in this country of teaching people how to handle money. And when we pass, to have that big chunk of money just come into our hands, whether at 35, 40, 21, even those stages, we're not prepared for it, okay? And control and protection is what should really be around wealth. And if you give that stuff straight outright to the kid may mix it with their spouse's money, so divorce can get it. They may go blow it. If they've got other social problems, whether it's addiction or they've got a abusive spouse, it may quickly be depleted. So you want to provide for them, but you want to protect them too. So really think about other ways to give it instead of giving it outright, okay? Give it some kind of trust. At least put it in a trust so that it's outside of divorce. In Minnesota, if you leave things to your heirs and you have a spendthrift clause, divorce can't get it. You also can have strings on there for the trustee to say, hey, is what they want to spend the money on, is it part of my values? This is supposed to be for the education for the grandkids and for them. What are they really going to use it for? The other piece being, what if they have a catastrophic accident or they just get involved in some lawsuit? You don't want it to be just available for the creditors to take. And it's much more difficult for your heirs to protect the money than it is for you to provide the protection of the trust. Because when you make it for them, it's a third-party settled trust, so it's got a lot of protection. When they make it for themselves in Minnesota or do those other kind of plans, it's a lot harder, and a lot of times they can forfeit most of the protection. So you've taken care of your family your whole life. You've worked hard to provide for them, and don't skimp out on when you hand them what's left when you pass away. Give them some things that will take care of it. Do be proactive. If they're minors, you got to do this because otherwise it's going to be wrapped up in court with the court guardian looking at it. If they're special needs, give it to them outright can destroy benefits. We'll talk about those things in future videos, but put a lot of thought into how you're going to give this to the next generation, and don't just limit yourself to giving to them just straight outright or at stages at certain ages. Really think about what you want it to be used for and make sure it benefits the next generation. You have that control, and that's the control that really should be there. I mean, you took care of them, you raised them, you looked out for them. You're probably going to be the patriarch or matriarch of that family by the time you pass away, and that's the role you play. You play the role of that guidance and wisdom and advice, and all those things you wish you knew when you were 30, wish you wouldn't have done with money when you were 30, when you were 20. You can make it impossible for them to do, and they can benefit and still have access to money and have a great life. And it won't do any harm. Remember, do no harm, and you do a lot of harm most times when you give it to it outright. So think about those things.